This awareness campaign is brought to you by The Sentinel, sworn to serve and protect Pilmico partners through risk management. Singapore Personal Data Protection Act or PDPA. Have you ever heard the line, "Ignorance of the law excuses no one"? This means that not knowing about a law does not excuse you for violating it. What is Singapore Personal Data Protection Act of 2012 or PDPA? PDPA is a law to govern the collection, use and disclosure of personal data by organizations in a manner that recognizes both the rights of individuals and the need of organizations to collect, use, or disclose personal data for purposes that a reasonable person would consider appropriate in the circumstances. The Act has come into full effect on the 2nd of July 2014 and has been updated recently with the new amendments that took effect last November 2, 2020. Why is it important? The Act is a necessary and important precaution in a world that has now shifted towards the digital age. Data is one of the most important assets of a company. For that reason alone, data protection should be a top priority. Why do businesses need to comply? The reasons are: first, the financial penalty cap for organizations is set at 10% of an organization's annual turnover in Singapore dollars, or 1 million Singapore dollars, whichever is higher. Second, additional penalty for the do not call provision for organizations is set at 5% of annual turnover in Singapore dollars, or 1 million Singapore dollars, whichever is higher, and 200,000 Singapore dollars for an individual. And last one, any person guilty of an offense under subsection 1 shall be liable in conviction to a fine or imprisonment for a term not exceeding 12 months or both. What is personal data? Personal data refers to data about an individual who can be identified from that data, or from that data and other info the organization has or is likely to have access. Includes electronic and non-electronic data, whether data is true or false. Personal data under the PDPA may include the following: full name, NRIC or passport number, photograph or video image of an individual, mobile telephone number, personal email address, thumbprint, and lastly is name and residential address. Personal data of deceased individuals. Data protection for a deceased individual is extended for up to 10 years from the date of death. Only disclosure and protection rules apply. This is intended to minimize any adverse impact of unauthorized disclosure of such data on family members of the deceased. Do note, the contact information you provide for business purposes, also known as business contact information, is not covered under the data protection obligations. This can include your name, designation, business telephone number, address, email address, or fax number, and any other similar information about you. There are 10 main obligations of the data protection provision. First is consent, purpose limitation, notification, access and correction, accuracy, protection, retention, transfer limitation, accountability obligation, and lastly is data breach notification. First is consent obligation. It is an organization collecting, using, or disclosing personal data are required to notify the individual of the purposes for the collection, use or disclosure, and obtain his or her consent. Note that organization must not, as a conditional for providing a product or service, compel the individual to provide consent beyond what is reasonable to provide a product or service. Second is purpose limitation obligation. An organization may collect, use, or disclose personal data for reasonable appropriate purposes and if the individual has been informed of the purpose. Note that clauses such as for any other purposes that the organization deem fit are generally not considered reasonable. The third one is notification obligation. Organization must notify the individual of the purpose for which it intends to collect, use, or disclose the individual's personal data on or before such collection, use, or disclosure of the personal data. The next one is access and correction obligation. Under it is access obligation. Upon request, organizations are required to provide an individual access to his or her personal data. Respond to the request as soon as reasonably possible and provide an interim written reply if the request will take more than 30 days to process. The interim reply must provide the time by which the organization can respond to the request. When not to provide access, cause immediate or serious harm to your safety or physical or mental health, threaten the safety or physical or mental health of someone else, reveal someone else's personal data, reveal the identity of the person who provided your personal data, or be contrary to the national interest. The next under it is correction obligation. Upon request, organizations should correct an individual or omission in an individual's personal data. Respond as soon as reasonably possible or provide a written interim reply in 30 days. The interim written reply must provide that time by which the organization can respond to the request. Do note, no fees may be levied. When not to provide correction, alteration of an opinion kept for evaluation purpose, and request pertains to a document relating to a prosecution if proceedings have not been completed. Accuracy obligation. Organizations must make reasonable effort to ensure that personal data collected by or on behalf of the organization is accurate and complete. If it is likely to be used to make a decision that affects the individual or disclosed to another organization. The next one is protection obligation. An organization must protect personal data in its possession or under its control by making reasonable security arrangements to prevent unauthorized access, collection, use, disclosure, copying, modification, disposal, or similar risk. There are several measures of protecting personal data. These are administrative, physical, and technical measures. Administrative measures. Examples are non-disclosure agreement, security policies with disciplinary consequences, regular training sessions, and others. Physical measures. These are marking confidential documents clearly and storing them in a locked cabinets. Use privacy filters on computer screens. Properly dispose documents containing personal data and ensure that the intended recipients of the personal data is the correct recipient. Technical measure examples: ensuring computer networks are secure, encrypt personal data, activate self-locking mechanism on the computer, install computer security software, and securely erase personal data in IT devices to be recycled, sold, or disposed of. The next one is retention limitation obligation. Organization should cease to retain documents containing personal data when personal data no longer serves the purpose it was collected for, and retention is no longer necessary for legal or business purposes. The purposes for retention could include the following: for legal proceedings, for producing annual reports, and for generating performance forecasts. Ceasing to retain personal data. An organization ceases to retain personal data when documents are destroyed, disposed of in an appropriate manner, returned to the individual concerned, transferred to another person on the instruction of an individual concerned, and lastly is anonymized, removal of identifying information. The next one is transfer limitation obligation. Organizations that transfer personal data out of the Singapore must take the necessary steps to ensure compliance with the PDPA. For example, appropriate security policies and measures that safeguard the personal data in accordance with the PDPA, or personal data will only be used in accordance with the PDPA. Next one is openness or accountability obligation. An organization is required to appoint at least one person to handle the development and implementation of its data protection policies and practices, including developing a process to receive and respond to requests for information and complaints on the above, communicating to staff information about the data protection policies and practices, and making information available on request about its processes for handling complaints. And the last one is data breach notification. Data breach means the unauthorized access, collection, use, disclosure, copying, modification, or disposal of personal data, or the loss of any storage medium or device on which personal data is stored in circumstances where the unauthorized access, collection, use, disclosure, copying, modification, or disposal of the personal data is likely to occur. This is the end of Part 1 Privacy Learning session covering the 10 main obligations of the data protection provision. See you at Part 2, the Do Not Call provision or DNC. Thank you for learning with us.